what promises to be an interesting panel on data breaches and privacy, so thank you for coming to this presentation. Firstly, to introduce myself, my name is Ailidh Callander. I'm a legal officer at Privacy International, an international NGO fighting for the right to privacy around the world. We work with an international network of partners. And we fight to challenge corporate and state surveillance and data exploitation. And part of this includes pushing for stronger data protection laws around the world. So here with me today are our moderator, Esther Keymolen from Leiden University, Christiaan Svanberg from the Danish National Police, Susan Gonscherowski from the Independent Centre for Privacy Protection, Kristian Albert Thijm from the law firm Bureau Brandeis, and Lina Jasmontaite from the Law Society and Technology Studies at the Free University of Brussels. So I'll briefly introduce our topic before handing over to Esther, who will take things forward. So as I said, the topic for today is data breaches and privacy. It may seem like hardly a day goes by without hearing of another data breach in the news, and often massive ones at that. The Uber breach or Equifax are just some examples from 2017, and there's sure to be more in the next year. Data breaches often involve highly sensitive information and can have harmful consequences for the individuals involved, disclosing intimate details about people's lives, their relationships, their financial status, and their location. So from an individual perspective, that often raises questions about what can you do about it and have you been affected? And one way legislation has responded to those questions is requiring mandatory data breach reporting to the regulator or to the data subject, or in some cases both. This is something that's been in place for a number of years in many jurisdictions. In some EU jurisdictions, I think, such as the Netherlands, in certain states in the US, and other countries, for example, Colombia. But for many countries in the EU, for example, in the UK where we're based, this is something new that data controllers are going to be grappling with in GDPR. As many of you know, GDPR introduces the mandatory reporting of data breaches to the regulator, the supervisory authority, within 72 hours of having become aware of the data breach, unless it's unlikely to affect the rights and freedoms of the data subject. And similarly, there's a requirement to notify data subjects if there's a high risk to their rights and freedoms. So that's something that requires processes in place to ensure compliance and to also kind of realize individual rights in this respect. And there's also requirements in terms of what has to be notified and how these breaches need to be recorded and dealt with going forward. So this raises a number of questions that we're going to be addressing here today on the panel and hearing from the panelists, such as how to ensure that the obligatory reporting does facilitate individual rights and protect them. How can one evaluate the risk, and looking at the risk thresholds that the GDPR proposes, for example. And tied into this, in the GDPR, there's the right to compensation. So when there is a data breach, how do individuals claim compensation? And in those cases, how do you quantify the damages in those claims? So these are just some of the questions our panelists will be covering today, and I'm looking forward to hearing their views on these and hearing from questions and comments from the audience. So I'll just quickly introduce Esther. Esther is an assistant professor and the director of education of e-law at Leiden University. She's specialized in the philosophy of technology and philosophical anthropology. Her research and teaching is interdisciplinary in nature and focuses on a number of areas, including technology and trust as regulatory strategies, philosophical and ethical implications of the use of digital technologies, and privacy. So with that, I'll pass over to Esther, who will introduce our panelists and kick off the discussion.
Thank you. Well, a philosopher as a moderator might be interesting because I actually see my role as a moderator to ensure that you, the audience, have enough time to ask questions. And in order to do that, I will keep an eye on the time and I will annoy the panelists with these messages that they only have 5 to 1 minute left to end the presentation. And of course, it's a very topical panel. Data being compromised, how to fix it, and I'm really interested in knowing the answer to that question. So, looking forward to our panelists' presentations. I will introduce every panelist, starting to my left, Christiaan Svanberg from the Danish National Police. He has more than 10 years of experience working with EU data protection law and policy from early years at the Danish Data Protection Authority. He also spent 2 years then on the Article 29 Working Party. And very interesting, he co-chaired the expert-level negotiations in the EU Council of Ministers on the GDPR in 2012. So he must have some very interesting insights on our topic. And I hope he will be sharing them with us. So I would like, without any further delay, give the floor to Christiaan.
Thank you very much. Well, like Esther just said, I had the pleasure of chairing the initial negotiations back in 2012 when Denmark had the EU presidency in the DAPEX Working Party. And maybe just to give a sort of a basic outline, my point was today to maybe give some history on how did we end up where we are now in the legal text in the GDPR. What was some of the process that led to the current wording of the GDPR or the final wording. And also maybe give a brief practical example, because actually in Denmark we've already implemented the directive, the police directive that was negotiated in parallel with the GDPR due to some issues regarding Europol and our opt-out. So we've actually for almost a year now been covered by in the police and law enforcement sector by the new rules. So we've also had to live under the wording, which is actually identical to the GDPR on data breach notification. So wanted to give a little bit of an example and maybe illustrate some of the issues that this gives rise to. But basically what happens when a proposal that has the size of the GDPR and the scope of the GDPR lands on the table of the negotiators is that everyone breathes a big sigh and says, oh my God, this is going to take a while. This landed obviously in January 2012. Actually, it landed probably in October, which was when we had the unofficial draft leak. So everyone was prepared for a very large legislative proposal. What you do initially in the council is you basically ask all the member states to give their general comments on the proposal. So you go around the room, that could take probably a day or two, and ask everyone to give their initial thoughts on the proposal. And one of the things that definitely stuck out, because imagine it's like you're surveying a landscape. So you're seeing there might be mountain peaks, there might be issues that you really care about, there might be valleys, there might be things you don't really notice at the first reading. But some of the things that definitely got attention was data breaches. And I'll speak a little bit on why that was, if I can get the clicker to work. Yes. So obviously, everyone noticed immediately off the bat that there was this deadline set for when the breach notification had to be carried out, and it was initially set to a deadline of 24 hours after becoming aware. That was very clearly, very early identified as something that was not going to be acceptable to member states. I think everyone recognized that. Taking into account something like a weekend, there could be many issues that would not be a workable setup. It also initially in the Commission proposals covered any personal data breach, which is a defined term. I'll get back to that later. And then obviously an obligation for the data processor to alert and inform the controller immediately once he becomes aware of the data breach. Let's see if we can get it to move. Yes. But under the actual final GDPR, it covers any personal data breach unless the breach is unlikely to result in a risk to the rights and freedoms of natural persons. That's a very abstract term. It gives some challenges in the practical day-to-day already, and I think it will going forward. It also says specifically that the deadline was now 72 hours, basically based on the premise that being able to answer some of the specific questions that you're obligated to notify the DPA about is going to take some time. Even if you are a well-run organization that has a full overview of where your data are, uncovering a data breach and describing it takes time. But also one of the points that was raised in council was that this is not really the first thing we want people to be busy doing when they have a data breach. The first thing we want them busy doing is stopping the breach, finding out what is happening, and acting in some way to mitigate the circumstances immediately. Of course, this is still important, but at the end of the day, this is not really the best interest of data subjects or businesses to be worrying about meeting a 24-hour deadline. We want them to spending the initial couple of days figuring out what is the issues, how do they handle them, how do they need, is this a consistent attack, are they being hacked, is a criminal activity at play, is it a state actor? Depending on who you are and what is happening, there could be a lot of legitimate reasons to wanting to have some time to sort of gather your thoughts, survey the situation, and report in due time. So, and then the obligation on a data processor was changed to notification without undue delay. In that regard, it's actually interesting to take that specific issue of the data processor having to notify the data controller, and then holding it up against the provision in on fines in Article 83, specifically Section 2, literal H, where one of the mitigating circumstances when setting out administrative fines is actually whether and to what extent the controller and processor has notified an infringement. And obviously for both parties, this could be an infringement of GDPR, not notifying that a data breach has taken place. This creates a sort of an interesting tension, because what if the data controller is not interested in notifying or doesn't respond to the data processor's notification that a data breach has taken place? Imagine you're a cloud provider. You might have 100,000 customers. You have a data breach. You notify all of them that the data breach has occurred. But you also want, for instance, if you want to mitigate the chance of getting fines, to be able to notify that to the relevant DPA. So there's a sort of an interesting issue here, which also relates to the basic fact that as a data controller, I would not be happy that the DPA knows that I've been subject to a data breach before I tell them. So in practice, I think that's already a very interesting element in negotiating data processing agreements. How do you actually scope out who does what in regards to data breaches between the data controller and the data processor? But just to move on the second article that is relevant here, Article 34, which deals with when you have to notify the data breach to the data subjects. The initial proposal has a sort of very long description, says when it's likely to adversely affect the protection of personal rights, except when you could demonstrate to the DPA, because initially, of course, under the Commission proposal, any data breach had to be notified. So the process was initially by the Commission thought out to be, you must notify any personal data breach, and then you must demonstrate to the DPA if you have taken appropriate protective measures that could render the data unintelligible to anyone who gets access to them. The deadline was then be after notifying the DPA. But in the final wording of the GDPR, it concerns only when you have to notify data subjects is only when it's likely to result in a high risk to the rights and freedoms of natural persons. That's why one of the things that the Article 29 Working Party has already been looking at is how do you define when something contains a high risk. So that's very useful that they're looking at that. The deadline is without undue delay, but then you have specific exceptions. So you don't have to notify the data subjects if, for instance, data is unintelligible, for instance, by the use of encryption, if you have been able to take subsequent measures which mitigates the risk, basically, so it's not likely to materialize, or notification would involve a disproportionate effort, but then you still have to do some kind of public notification. It's interesting in that regard to say maybe look at a practical example just in closing. So imagine that your IT department calls you up and informs you that the usernames, i.e. the login names of some of your employees, 12 employees, by mistake has been sent by an email to an external researcher who's working for your organization on a project. They subsequently contacted the researcher within minutes and informed them of the data breach. And asked them to not read the email and delete it immediately, which the researcher then confirmed. was that he did not, and that the email was subsequently deleted. So is this a personal data breach under the GDPR? Well, a breach is defined as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure, which is probably what we have here, of personal data that has been transmitted, stored, or otherwise processed. So on the face of it, yes, we are not, this is actually a data breach. So unless we can use the GDPR's exception on whether or not it is likely to lead to a risk to the rights and freedom of natural persons, you would actually, even in such a relatively benign, you could say, case, have an obligation to notify. Obviously, this is a difficult assessment. You need to balance the interests of all parties. This actually happened in real life. This happened at the Danish police. We were considering a lot of the aspects of this case. So we basically said, well, basically the risks for the individuals are fairly low. It's the username they use at work. It was sent by email to a trusted third party who we work with that are covered by ethical rules and by contract, and they confirmed immediately that they had deleted the email and they had not read it. But regardless of that, it still meets the formal definition of a data breach, at least you could say, and whether or not it is unlikely to lead to any risk for data subjects. That's, well, unlikely is a very, if you will, high bar to meet. Unlikely means it's not going to happen in 99% of the cases, probably. That's a very low bar in practice. So what we did was, obviously, we contacted DPA and said, this has happened. Our assessment is that we're not formally obliged to notify, because we, on the whole of it, feel that this does not meet the risks standard in the GDPR, and they actually agreed. But it's illustrated to say that this will happen every day across Europe, thousands of times probably. So it's good to note, at least, that the DPAs, when they elaborated on the data breach in their guidance in this matter, has actually decided that the low standard or the initial DPA notifications will not have to take place if data is essentially unintelligible to unauthorized parties, which basically means encryption, which is interesting because this is not what's in the GDPR. The GDPR only recognizes this in regards to data subject notifications, but I think it's a very wise move to say on behalf of DPAs, to avoid getting swamped, that also in the initial DPA notification requirement, you can take into account if data has been rendered unintelligible or will not be able to be used by unauthorized parties. And we could say here, to a large extent, it wouldn't be something that you could use by anyone outside our organization, because the way our systems are set up, having knowledge of what the username is fairly benign. It's not public, but it's fairly benign. So this is just to illustrate the practical issues.
Okay. Thank you. Thank you, Christian, for your very interesting and insightful presentation. Before we move to the next speaker, I would first like to open the floor for the audience. If you have any burning questions you would like to ask Christian, time is now. So if you want to stand up, and please use the microphone so we can all understand what you are asking.
Yeah, hello, good morning. I'm Alonga Rojas, last year's PhD student, currently in Lithuania. The Article 4 you just showed, is it of the GDPR or the 95 directive?
GDPR.
But it comes into force in May 2018. And do you still have to comply with it now without it?
Yes, because we have an identical wording in the police directive, which, as I said, we've already implemented in Denmark. So in law enforcement, there's a separate directive for data protection that was negotiated in parallel with the GDPR, and that has already been implemented in Denmark. So we're already caught by identical rules, but not the GDPR directly, but it's the same wording.
Okay. So, right. So that's Article 4 of the directive of the police directive was negotiated parallel with the GDPR, not the GDPR itself.
No, the GDPR. The definition of a personal data breach.
Well, okay, talk about it later.
Any other questions from the audience? Otherwise, I got a question from a panelist, and tend to be flexible about this. If you ask it briefly and short, then...
Very kind, just to get the discussion started a little bit. No, I was intrigued by the last example you gave and the decision not to notify. And if we would turn the situation around, what would be the argument against notifying this particular breach at the DPA?
The argument against, the argument against was a holistic assessment of the risk to the data subjects, i.e., what could someone do with their username on the outside.
I can appreciate that you made, you went through the legalities and you balanced all the circumstances at issue, and then at the end you decided, okay, we're not going to notify. That's of course a decision, always a difficult decision, and a decision that every day, as you rightfully said, around Europe organizations have to take. You can also say, well, let's not go into this difficult assessment. There has been a breach, as you rightfully said. Let's notify.
Yeah, but I think what we had in the back of our head was also precedent. We wanted to make, so actually what we did both. We called the DPA and said, this has happened. This is new to you. This is new to us. This is our assessment. Do you agree that we don't formally have to notify you? And they did. Yeah. So in future, similar cases, we will not notify. But our concern was basically once you start looking at when is the unlikely standard met, that's kind of difficult. So I think it's important that the Article 29 working parties tries to make this workable in practice. And our concern was basically if we feel that we're obligated here, we're going to be obligated in a lot of situations probably.
Yeah. Now it's a difficult decision to make. But if you decide not to notify, and then the person who informed you that he had actually deleted the data turns out not to have done that, and some other damages have incurred, you will be liable. And you can circumvent that risk by notifying, I would say.
Yeah, sorry. Maybe. It's a very interesting discussion, but I have to be strict, and otherwise I have to take time of your presentation, Christiaan.
Very good.
So be aware of the questions and the time you take. Okay, I would like to move further to our next speaker, Susan Gonscherowski from the Independent Center for Privacy Protection, Schleswig-Holstein. She studied political science and public law at the University of Kiel, and she also started a doctoral candidate then. Her general research focuses on compliance with European and German data protection law, and this translates in different, more specific research interests, such as how to provide reliable, authentic, end-to-end encryption keys through email providers. And this is, of course, second one is important to our panel, how to come to an effective information and breach notification after a data breach. So Susan will, in her presentation, highlight the role of regulators when it comes to breach notification. So Susan, the floor is yours.
Thank you, Esther. You can all hear me quite nicely? Okay.
Take the microphone a bit closer.
Okay, better now? Okay. I'm probably going to speak up while I'm talking. So I would like to start with a short sum up of what Kristian just said and summarize how the data subject actually gets to know that there has been a breach and that there might be or that there is a high risk for one's personal rights and freedoms. And as Kristian just said, there are two possible ways. Either the controller communicates the personal data breach directly because of the assessment the controller made, or the second way, the supervisory authority requires the controller to communicate the breach. That would be the case when the assessment might be a little off from the controller. So basically we have three preconditions of breach notification. First, the controller needs the knowledge that there actually was a breach. Then the correct risk assessment that there was a high risk. And third, that the data subject is actually identified. If these preconditions are met, then we don't have any problems, and the subject can be informed and can take precautions or other measures. but what if these preconditions are not fulfilled? For example, the controller is not aware or not sure, then we have the 72-hour deadline to further evaluate the situation. What if the controller assessed the wrong risk and said it's not a problem? Well, it has to be documented anyway why they didn't inform the supervisory authorities, so they can always be liable afterwards. So the precaution the controller will take is probably the same that you took, that you are going to ask informally, do we have to notify you? And then the authority is going to decide yes or no. And the third and major problem, in my view, is that the controller can't identify the actual data subject. So there are two options for the controller left. The first one, public announcement of a data breach, where you can never be sure that it actually reaches all the data subjects. And the second one is that the controller finds a similar way to inform the data subjects. Well, before I go deeper into that one, I would like to tell you about the risks around all the knowledge about the controller and some other risks we already determined. The knowledge that a data breach occurred might not be possible because either the responsible controller is no longer available, maybe because there was a bankruptcy or they terminated this service, or the personal data is publicly available, but it's not determined who the controller is and where the breach occurred. So you would have to notify the data subject, but there's no one responsible of doing that. And yes, the question who is obligated to communicate the breach is also one of our research topics. A second risk assessment is that the unidentified data subjects might be unidentified because there's no recent contact information, which is actually possible because of data minimization. You don't need any contact information for your service, then you won't have the ability to contact your data subjects. And of course, there's always the possibility of providing an absolutely anonymous service, or that because of the data breach, you might have lost the contact information you would need, either because the email address may be compromised or because you don't have any information left because there was ransomware at work or something like that. So as you can see, we are kind of heading for a dead end in these situations. But the GDPR actually provides a fallback plan. And that plan is that the main goal is to notify the data subject. So you may have to take a little detour and look for clues in the GDPR aside from the obvious ones. The similar way to communicate a data breach might be, as we're researching right now, that the supervisory authorities themselves inform the actual individuals because they are able to get the information they need. There's also the possibility that controllers could establish a pool of trusted controllers and exchange the necessary contact information in case the information is lost. Of course, here the main aspect would be that we don't create any more profiling or any more links that are already available. In the idealistic way, the controller shouldn't have more information in the end than they had before, beside the contact information they need. And of course, there's Article 15, the right of access by the data subject, where you can actually provide the information that there was a major breach, but you weren't able to determine who was compromised or whose data was compromised. So anytime a data subject is asking for some information about its own data, then you could provide the data subject with the information they need that there was a data breach. So the conclusion is that controllers and supervisory authorities should look into the flexibility clauses and come up with some creative means of informing data subjects. And the controllers, of course, need to take into account what happens in the worst case when they can't contact the data subject, and depending on their kind of data processing, think of a different way to contact the data subjects in case the standard measures won't work. So that would be it from my side. Thank you.
Thank you so much, Susan. Thank you for your presentation. Same question to the audience. If you have a question, a burning question that you would like to ask Susan, then time is now. And if not, I'm quite sure. Yeah, our panelists. Yes.
So Susan, during your presentation, you very much focused on how to inform individuals and what could be mechanisms to do so. But maybe you could just briefly, talk about what individuals could do actually after receiving a notification of a data breach.
The actions an individual might take are quite different because it depends on what kind of data breach occurred. If my login data was compromised, then maybe changing my password is absolutely okay, and then everything will be fine. If my social security number is somehow available, then there's actually not much I can do, because this one is something I'm assigned to for a lifetime. So all I can do is take a few precautions, maybe be careful where the security number may be used, and ask the authorities what to do if someone is using my security number. But for an individual, there's actually not much they can do, because you can't just change some numbers assigned from the official side.
So should individuals expect to have that kind of recommendations to take action or not to take action?
Yes, of
in
course.
that kind of notifications?
Yes, of course, the controller needs to provide the information if there's something that the individual can do, or if there is some authority or some other point of contact they can go to get more information, or if there's just nothing they can do and they have to maybe go to the police just for the liability afterwards. That would be the worst case, of course.
Thank you. Yes, there is time for one more question. I see some gentlemen in the back. Yes.
Hi, it's always nice to have a case study or just working on a case, thinking about the abstract legal aspects. So my question will be, are German police investigating a case of hacking and some organized crime, maybe direction Russia or something? They're on servers in other countries, and they find on these servers a couple of million email addresses. And it's all German email addresses, 4 million. How about the process of notification to those citizens? What would be your first thought? I think there was a related case in Germany. It took them 6 months, I think, to build a web page for the citizens to just check for themselves whether their email is part of the what the folks had.
these information services provided by the German institution, BSI. It's one way. There are actually also some other actors who provide this kind of service. But of course, the more direct way I would recommend, and that's actually what we are trying to accomplish in our ID project, is that because of the email address, you already have the domain. So you have a controller at your hands that you could inform, hey, GMX or Gmail or whatever, some of your customers are popping up in our database, and maybe the email provider could inform their customers, so you wouldn't have to wait for the actual individual to maybe notice in some news feed that there was a data breach about email addresses and then check for themselves. But you could actually send an email to the individual and then recommend some precautions. For example, change your password, or if you need further information, please contact the BSI or your local police station.
Thanks. How about the Danish police? Would they inform on a case like that, finding?
Well, I mean, I think it's important to formally note that that would not be something that would be covered by the data protection rules obligations for us to notify. So we would do this only based on a specific assessment, feeling that the interest at stake warranted and we have the necessary information. We could very well inform the original data controller, and then that would obviously trigger their individual obligation to notify if they were not aware that they've been breached. So it would be a specific assessment. We do it in some cases, but only when it's maybe information that is really integral to the individual. So we've had cases where there were breaches that were being used to put pressure on a plastic surgery clinic, where all the files of the patients had been leaked, and it was in another EU country, but a number of Danish citizens were involved. We tried to reach out to the Danish citizens that we could identify to make them aware that their data had been leaked in that manner. But that was very specific, sensitive with photographs and everything. So then we would do it. But other than that, we don't view it as our responsibility to trigger that notification.
Thank you. Yes, I would like to move to our third speaker, Kristian Alberdingk Thijm. He's a partner of Bureau Brandeis. He specializes in digital copyright, liability of intermediaries, privacy and free speech issues. He's both a trusted advisor to his clients such as KPN, Netflix and eBay, and an experienced litigator. Besides his work as an attorney, he is also senior lecturer at the University of Amsterdam. And in his presentation, he will go into some practical issues concerning data breach notifications in the Netherlands, discussing the possibility to claim compensation as a data subject and the relevant criteria thereof. Christiaan, the floor is yours.
Thank you very much, Esther. It's a pleasure to be here at Cpdp. I was here in 2012 hosting a panel on copyright enforcement and privacy in peer-to-peer networks. And it really feels like a century ago. We didn't have the GDPR in 2012 yet. Just a proposal we've just heard. I want to share some personal thoughts about data breaches and damages. So not so much going into the details of notifications, etc., which is of course a very interesting subject, but I think Kristian and Susan have already hinted on those topics. So maybe for the discussion later, that will be something to come back to. Now, whoever has been the victim of a break-in experiences an infringement of the core of the right of privacy, I would say, the invasion of the home. Someone entering your home, violating your most personal precinct, going through your personal belongings, ransacking your house, and that's, well, as anybody who would have experienced that, that is a truly horrible situation. In such such a situation, the thieving, the stealing, or the appropriation of personal belongings is not so much the issue. It's the fact that somebody has trespassed upon your personal space, the space where you live with your family, your children, your spouse, and anyone who would report that incident to the police would get an immediate ear from the competent authorities, and they would very much reflect upon your feelings. Your insurance company would very likely compensate you for full damages. Now, let's fast forward to digital break-ins. Imagine that you have experienced a digital break-in. In that case, you are under a duty to report the break-in to the competent authorities within 72 hours. You will immediately, upon notifying the break-in, become a suspect yourself. Questions to be asked are whether you implemented appropriate technical and organizational measures to ensure a level of security appropriate to the risk and to protect the personal data that you have had in your belongings, and ultimately you may be fined. Now in 2012, my client Royal KPN, the former telecommunications incumbent, was successfully hacked. And in 2016, it was ordered to pay 364,000 euros as a penalty. The highest administrative court in the Netherlands ruled that the fact that no personal data was compromised in that instance as a result of the hack did not matter. The mere fact that the hacker itself had access to the personal data, despite the fact that he didn't steal it or take it away or compromise it, was sufficient for the penalty. KPN had admitted in that instance that the hack itself shouldn't have occurred. But it argued that it encounters 60,000 attacks on a daily basis, and somehow it seems to be able to resolve those accordingly. And it said, well, we are going to be the victim of a successful hack again in the future. And in our opinion, it's very important the way we deal with the hack, the way we react to the possible data breach involved. And the competent supervisory authority, and I went through 3 court levels in the Netherlands, all said, now the way KPN responded to the hack was very diligently, timely, and they did a really great job. But nevertheless, the fine, the 364,000, was not lifted. It remained in place. Now this instance occurred under the Telecommunications Act and implementation of the e-privacy directive in 2011 in the Netherlands, and therefore the competent authority was the Telecommunications Authority. Since 2016, we have implemented, similarly like the Danish people, we've implemented data breach provisions within our Data Protection Act. Now, instances like these give rise to questions about penalties, but also about damages. So on the one hand, you can argue, how should a competent authority assess the amount of damages or the height of the penalty that needs to be paid by whoever violated the data breach provisions? And on the other hand, the question, in which circumstances do individual data subjects have a right to compensation? And if so, how high can the compensation be? Now, the GDPR does not give a lot of guidance on the issue. What we know from experience in the Netherlands is that in 2017, 10,000 data breaches have been notified to the DPA, the Data Protection Authority, and that is twice as much as the amount of data breaches that occurred in 2016. But so far, the DPA did not hand out any penalties in this matter, despite its competence already to do so, penalties amounting to a maximum of 820,000 euros. The DPA has commented on the fact that it didn't hand out any penalties and said, well, penalties, in our opinion, should be a last resort when warnings, they argue, suffice. So there are no cases in the Netherlands reported whereby data subjects themselves have successfully obtained compensation for data breaches. And the KPN case I've just mentioned is so far the only case known in the Netherlands in which a penalty was attributed upon a third party, and that was the Telecommunications Authority. Now, if you read Article 33 of the GDPR about data breaches, that provision does give some guidance about the criteria that may be relevant in determining the damages and the amount or the height of the penalty itself. In notifying a data breach, one has to describe the categories and the approximate number of data subjects and the categories of personal data involved. And in addition, one has to describe the likely consequences of a personal data breach and the measures taken or proposed to be taken. Now, reading that provision, common sense would dictate that the penalty or the amount of damages claimed by data subjects will depend on similar criteria. So, should a data breach involve a large number of people, sensitive data such as passwords, and may result in a third party accessing your email account, for instance, and the breach was not notified or not notified timely to the competent authorities, those circumstances would lead to a higher penalty or more damages. Now, if you look at the damages to be claimed by data subjects themselves, Article 82 of the GDPR is interesting. The provision stipulates that any person who has suffered material or non-material damages as a result of a violation of the regulation, including data breaches, shall have the right to receive compensation from the controller or processor for the damage suffered. And the second paragraph determines that any controller involved in processing shall be liable for the damage caused by such processing. A controller shall be exempt from liability under paragraph 2 if it proves that it not in any way is responsible for the event giving rise to the damage. As such, the burden of proof is on the controller to show that he is not in any way responsible for the event. And this, of course, is a very heavy burden of proof, and any data breach will very much likely lead to the fact that the controller is by law liable for damages and should pay personal damages to the data subjects involved. Now, if you look at the amount of damages, recital 146 of the GDPR is interesting. In that recital, it is said that the concept of damages should be broadly interpreted in the light of the case law of the ECJ in a manner which fully reflects the objectives of this regulation. And a broad interpretation of damage would include both material and, of course, immaterial damages. In a case concerning portrait rights in the Netherlands, the Dutch Supreme Court has determined that an infringement of privacy leads eo ipso, dus by itself, to a claim of immaterial damages. And of course, we don't know anything about the height of the immaterial damages to be awarded. But if we again look at recital 146, it says that the data subject should receive full compensation and also effective compensation. Now, the word effective is interesting in recital 146 because we don't know what that means. But I would argue that effective refers to some kind of punitive damages. And as such, damages could also be an instrument to ensure that a controller or society at large abides to the rules in the GDPR. Damages may also have a warning effect to others, of course, as we know. Now, especially in the situation that we have now in the Netherlands, where the DPA is not handing out penalties, I would argue that damages claims for data subjects may be equally high, i.e. up to 20 million euros, if we like. Now, it's of course very interesting to see the first case come about. You can imagine in the Uber case that some kind of class action would come about, and I'm hoping, as a litigator and a lawyer, to see a lot of case law come about. Thank you.
Thank you, Christiaan. Thank you for this presentation. There might be some questions from the audience. Yes, I see people standing up. Run for the mic.
Hello, Gloria González Fuster from the Free University of Brussels. I think it's a very interesting subject, the damages. And I was wondering, so it's not a question for you, but for the other speakers, from your experience and your knowledge in your member state, do you know more about the compensation, about the damages, how to calculate the damages? Thank you.
Well, at least in Denmark, this is actually an interesting and an open question. I actually agree. I think, as a general point, I think compensation could be a real risk going forward. But this is completely new to us. Just the concept, at least in Danish, that you would have the union consider getting at least substantial compensation for data breaches. So I think we're very much also waiting for hopefully some ECJ jurisprudence. I think that's going to be, until that really comes along, we will not know what the real standard is. But there is some interesting practice already. So it's very generally worded. There was clearly during the legislative process, there was clearly some disagreement on what was this specific intent, but it ended up being quite broad in my view.
In Germany, we have kind of a different problem, because in Germany the class action is not common, it's not known, and we are currently fighting to finally have class action for cases like that, because otherwise every individual has to fight for their own right, and it's taken up to even in the Schleswig-Holstein authorities, we've been fighting for 10 years now against Facebook, so you can imagine what it costs for an individual to take action against a breach.
Ailidh, do you want to add something from the UK perspective?
Yes, just briefly, the question of material and non-material damages is something the courts in the UK have been looking at in data protection cases in the last couple of years, and I think it's quite interesting what Kristiaan said about you might have a regulator giving a lower fine or not taking any action, but individuals might proceed with a compensation claim, which has, I think, and still is very difficult for individuals to do. We've just had a judgment in the UK where a supermarket was found vicariously liable for a data breach in a case brought by, I think, 5,000 employees, but actually in that case the regulator hadn't taken any action. Because it's being appealed, the quantification of damages is delayed, obviously, but I think that it's something that everyone's going to be looking to, both in their member state and across the EU, in terms of how damages are going to be quantified, because I think it's important for individuals, and it's also something that controllers and processors are going to be very concerned about, particularly because regulators are going to be very swamped potentially. So I think that's something that'll be interesting to look at going forward, and I think in part there's the collective redress provisions in GDPR are very important, and pushing for those is something that's going to be important too.
Thank you. Next question, please.
Andrew Adams, Major University. Given that we know from both previous court cases and from direct investigation, a lot of the harm from privacy violations often is very diffuse, very difficult to tie back to a specific data breach. But we're fairly sure that data breaches contribute to this and contribute in a significant way. Is there any concept in the GDPR or in the way it's being implemented as to that there will be funds set up to help people deal with the consequences, which may not be trackable to a specific data breach? For instance, there's large fines in there. Will any of that money be applied to try and help people deal with that?
Who wants to take that question? Do you? Christiaan or Christiaan?
Well, I can briefly comment to that. Not in particular in relation to data breaches, but of course the data subjects do have a lot of rights in general under the GDPR. nevertheless, in practice, and we will see how this will play out in practice, it will still be very difficult. I mean, take for instance a case the gentleman from Germany just mentioned the 4 million people that were involved in this data breach. How can they determine what the consequence of the breach has been? There's this website, Have I Been Bound, that you can check. It's a big database, and you can see in how many databases your personal data was that has been breached, and everybody was in the LinkedIn data breach database. But then we don't know who stole that data, what happened to our passwords, whether they are selling it, whether they are keeping it to invade our privacy at a later point in time. It's extremely difficult.
Thank you. Last question.
Hello, Tobias Morsches from Datenschutzraum Germany. I have a practical example, and I would like you to comment how the damages and compensations may be. A data breach occurred on an online game where a user lost his password, and it was publicly disclosed on the internet. It was a long password. And 5 years later, after this password has been in the internet all this time, the company he's working with was hacked using this password, and the attacker gained access to a very, very large number of credit card information on customers of this company. So we have the problems with the user not having different passwords for different systems and not changing the password regularly, but where is the compensation, where's the damage?
That's of course a very interesting subject, and the interesting thing on the one hand is that it's quite the damages are quite material in the sense that you can, and that is always an issue in these cases. I mean, as a gentleman before you said, how do you know what happened? But in this instance, you actually know what happened. The issue in determining the damages, the way to attribute the damages to the act itself, and whether there's a causal relationship between the two, is of course, as in all damages cases, a difficult issue. Now, in this case, it would very much depend on the fact whether the company knew about the violation and whether the company took measures, for instance, in order to change the password. Obviously, it didn't change the password, but if the company would have knowledge in this instance, or should have had knowledge in this instance of the violation itself, I would say that would lead to quite a high damage claim. Even more so if the credit card information was violated.
Sorry, I perhaps if you have time after the final speaker, then you're the first one that will get the mic. We will get the mic, but first I want to move to our final speaker, Lina Jasmontaite. She's a PhD student at the Vrije Universiteit, Free University of Brussels. She currently she works on the Horizon 2020 project titled Constructing an Alliance for Value-Driven Cybersecurity, Canvas, who is also the sponsor of this panel. She's a fellow at the Brussels Privacy Hub, and previously she worked as a legal researcher at Leuven University. I would like to give you the floor.
So thank you very much for this kind introduction. I also would like to thank the chair and the previous speakers for very interesting insights about the inception and meaning of the data protection notification mechanism as it is found in Articles 33 and 34 of the GDPR. It was also fascinating to hear that the practical challenges of claiming compensation for data subjects are vast and many. And yet the very idea of having data breach notifications to individuals is not only about informing them of a situation, but also about preventing them of becoming fraud victims. And in this case, transparency of data breaches should potentially help individuals when deciding upon entities to whom they should trust their data in the future. And indeed, this is a very reasonable expectation to have, provided that in the EU we have an average consumer who is regarded someone who is reasonably circumspect and able to look after his own or her own interests. And in the next few minutes, I will give you an example of another data breach that took place some time ago. And then I will draw some data that we could actually learn from the US. So, has any of you heard about the data breach of Ashley Madison website? Maybe the ones who have heard about it could raise their hands. All right, it's a great majority. I don't know the reasons why you know about it. But for the ones who don't know about it, I'll just say that Ashley Madison was an online dating service that was originally designed for people in committed relationships who wanted to cheat on their partners or spouses. And in 2015, this website claimed to be 100% discreet, and it was claiming that user data is secure, it's private, and that it's safe, and that it would never be compromised, and user identity would be made public only if the users decided to do so. And this very interesting concept of Ashley Madison attracted over 40 million of supposedly anonymous members to the site. Considering the moral implications of this website, the hacker group called the Impact Team hacked into parent company of Ashley Madison, and in this way it got direct access to the user database, which it eventually published. And as a result of this data becoming public, 4 class actions have been filed against the parent company of Ashley Madison, and several suicides have been linked to the data breach. And this is a very dramatic example, but from this example we see that maybe different harms that may follow a data breach. And it's not only about data theft and not only about undesirable exposure of data. And let's go back now to the question, what in Europe we could learn from the experience in the US. So as far as it seems right now, the US experience with data breaches is somewhat ambiguous. It is rather unclear what impact did notifications had on individuals and whether individuals got to understand more about risks associated with data breaches. And whether this understanding has improved in any way. And in US, in a majority of companies that experience data breaches are very quick to offer credit monitoring. And credit monitoring is recognized as a standard measure to take in a response to a data breach. And yet there's a huge debate about it, whether it makes any sense to do that, and whether offering credit monitoring for a year or another limited period of time can actually minimize impact of data exposure. We have a question that is also tackled on the other side of Atlantic that is very relevant for us right here, is how to quantify the injury and damage that individuals experience. And in next few minutes, I will just share some scattered data and that you may find interesting. So research data in the US shows that things like age, income, education, and the language in which notification is provided are very important. So it appears that adults that are aged 64 and more are less likely to become victims of data breaches. But if they do become victims of data breaches, then they are more vulnerable because obviously they have more assets and they have lower technological awareness. Now those in the age group of 35 to 64 are more likely to receive, to become victims of a data breach and so receive notifications. The other interesting finding is that income is a significant factor when considering data breaches. So the ones who belong to the wealthiest income group receive notifications at the rate more than triple in comparison to the ones who are in the lowest income group. And this is explained that the ones who are in the wealthiest income group, you know, they engage in financial and recreational activities with many more organizations, so they put themselves at risks more often and to a great extent. And so this, of course, could put at ease, you know, the great majority of researchers and academics, you know, because we don't fall within this wealthiest group of individuals. But the research data also shows that education is an important factor. So the ones with postgraduate degree are more likely to experience a data breach than the ones with just high school diploma. And the other interesting thing is that the ones with more education are more likely to refuse to take measures offered by companies that experience a data breach. The other interesting finding is that the overwhelming majority of individuals, that amounts to 89%, continue doing business with a company that experienced a breach. And in my opinion, this certainly provides very little incentive for a company to change its behavior, and especially to change its behavior with regard to cybersecurity protection. And it means that customers are not put off by data breaches, and it may be just because they receive so many of them, so they become desensitized to them. So this sunlight expected from data breaches does not really have much effect on individuals. And research data in the US also shows that 29% of individuals in general refuse to accept any guidance or remediation offered by the companies. And only less than 10% of individuals take additional action as a result of a data breach. So that could include, let's say, purchasing an identity theft protection or identity theft insurance. Well, now I know that all this information that you heard right now is very scattered, but I think that we can really learn a lot from it and make sure that data notification in the EU becomes meaningful. Of course, data breach notification as introduced in the GDPR is a result of a political compromise, and it's up to us to what we're gonna make out of it. And this information disclosure that is foreseen in the GDPR can be useful only to the extent that those who receive this information can actually understand and care about it. And for that, we need to develop new mechanisms and approaches that would provide individuals with more help in the wake of a data breach. And this, for example, could include a strict timeline of a notification and requirement to explain risks associated with notification. And certainly, the use of language is very important. So the language which is used in the notification should reach the individuals who experienced the data breach. And just now, like a few more words before closing. If we look at data breach notification requirements from a bit different angle, like sort of a spin-off of a right to know, then we clearly see that it's a targeted transparency policy which aims not only to inform the public, but it aims to reduce specific risks and improve particular aspects of data management and governance. So with this, I would like to end. Yes.
Thank you, Lina, for sharing these very interesting research results with us. I think it's time to close the panel. Unfortunately, we don't have any more time. But first of all, I would like to thank Lina. Do we
maybe we
still have. We didn't hear the guy with the bells, but
yes.
okay, we
Perhaps
just.
we can still take on some
Yes, you were the first in line to get the mic.
Yes, hello. My question is for Mr. Christian. Very rich presentation. I was busy noting down a few things. I kind of lost track, but I remember I had some 2 questions. In the first place, you mentioned the KPN case where the court, I don't know, the authority obliged them to pay a fine of 364,000 euros, but then you later said there has been no case in the Netherlands where data subjects were awarded compensation successfully. But then the 364,000 euros, was it a fine or was it given to?
Sorry for that misunderstanding. Okay. So the KPN case was brought under the Telecommunications Act.
Okay.
And the penalty. Okay.
Okay.
And the penalty was attributed by the Telecommunications Authority, so not the Data Protection Authority. So there are 2 separate entities in the Netherlands, so therefore this is the one and single example that we have in the Netherlands, and this was implemented in 2011.
Okay, very quickly. Second question, final question concerning. Because you mentioned the GDPR gives the opportunity for the data controller to avoid liability if he successfully proves he wasn't responsible for a data breach.
Yeah.
Now, but when we look at the Morrison case, which the first speaker actually mentioned concerning vicarious liability, for example, if I park my car outside and someone steals it and goes and crashes into a store, how do I become vicariously responsible for that? Because for me, when I look at the Morrison's case, the facts, it's just the same thing. Someone steals data and gives it out, and the company is held vicariously liable. Isn't this a case of force majeure, or is it like a case of the company?
That's an excellent question, thanks. And that's why I started with the example of invasion of somebody's privacy of the home, for instance, and comparing that. I think under data protection law, we look at break-ins or hacks completely different than we do in the property world, so to say, the offline world. And in the example, if somebody breaks into your car and he finds a USB stick in it with data on it, that will be a data breach, and I'm sure you'll need to pay compensation for that, I'm afraid.
A final short question, please.
Tobias Moschus again from Datenschutzraum. The question is, do we need a secure notification system? Because I have in my email thousands of breach notifications for services I do not even have, and they all put me to some Russian site that wants my credentials and something else. I don't know.
Yes, but I'm actually glad that you're still here, because I would like to make an addition to the question you asked before about the password change. And it's kind of related to your question now, because what technical and organizational measures does the controller take? That's always the first question you have to ask, because when some of my employees hasn't changed a password in 5 years, then I'm responsible as a controller, of course, yes. And yes, we do need a safe notification system, and we don't want, of course, to overload the data subject with warnings once, twice, or I don't know how many times a day. Of course, only the important breaches with the high risk should be mentioned, and but that doesn't take the controller out of responsibility, because first and foremost you have to make sure that there doesn't happen a breach. And then we can ask all the other questions.
Yeah, but of course this is an excellent question, and nobody is really given that much thought. In the US they're thinking about it much more, because it's spam, basically, all these notifications, and it's an invasion of your privacy. So we need to think up of a system whereby transparency and the right to obtain information, as Lina explained it, is awarded. And this must be given much more thought.
Thank you for your question and thank you for the answers. I would like, yes, a big applause, but first of all for Lina, because she was the driving force behind this panel, and well, thank you for that, Lina. And I also want to thank the audience for joining this panel and for your sharp and interesting questions, and of course a big applause for our panelists. Thank you very much. Enjoy the rest of the conference.